How you doing?
I'm good, Shannon. How are you doing?
Good. I'm here to talk about Prop 65, which is part of our larger California environmental practice that addresses all manner of issues in California. And California is at the forefront of environmental regulation consistently. Prop 65 is no exception. Can you give us a general overview of what Prop 65 is and what it does?
Absolutely. You know, at its core, Prop 65 is actually a pretty broad statute. What it is designed to do is to reduce exposures to Californians to toxic chemicals, but only two types of toxic chemicals, those that cause cancer and those that cause reproductive harm. It has no impact on chemicals that don't do either of those two things. And what it does is try to reduce exposures to Californians in the products they use, in their workplace, and also from environmental exposures. The one other aspect of Prop 65 is that it contains a prohibition against discharging any of the listed chemicals into sources of drinking water. That hasn't been such an important part of the defense bar's work in Prop 65 recently, but there have been a number of cases brought where plaintiffs are claiming that companies have discharged toxic chemicals into sources of drinking water, and Prop 65 is a very handy statute for them to utilize to get to that.
But with the exception of the drinking water piece, though, it doesn't actually require any reductions. It just is a right to know provision that creates incentives and then penalties if you don't do the warning. Is that correct?
Yeah, exactly. At a high level, it either requires a warning or it requires a lack of exposure to a listed chemical. But the exposure that can trigger a warning is at an extremely low level. One of the reasons Prop 65 has become such a flashpoint in California environmental law is because it's so easy to bring a suit under Prop 65. And the Attorney General tracks all the settlements that have occurred. Over the last several years, the average has been about $30 million in settlement payments by defendant companies in response to Prop 65 actions. But that's only the tip of the iceberg of what it costs a company to deal with Prop 65. You've got the costs that you're going to pay the plaintiffs, attorney's fees, you've got the penalties. You're also going to be paying your own attorney's fees. But on top of that, you've got business interruption, you've got compliance issues to make sure that products are manufactured appropriately, and you've got a whole supply chain of information you've got to deal with. So it's actually, even though it's only $30 million overall reported to the state, the cost to California to comply with Prop 65 is much, much, much greater than that.
So if I'm a company and I'm sending a product into California, what are the things that I need to think about? And how do you advise me? You're my lawyer. Tell me what I need to know.
Good question. So first off, technically Prop 65 only applies to businesses with 10 or more employees. So if you're under 10 employees, it's less significant, but we'll talk about that. It actually still applies to you in a roundabout way. So if you're going to be sending a product into California, you need to consider how your product was manufactured, what chemicals are in the product, and whether it may cause an exposure of one of the listed chemicals. Now, the chemicals on the list are extremely varied. It's everything from lead to arsenic to asbestos, chemicals that in everyday vernacular that are dangerous and probably should have a warning if you're going to be exposed to them. But as I said, there are over 900 chemicals. So some of the chemicals on the list also include aspirin. Some of the chemicals on the list are marijuana smoke, tobacco smoke, things that in California these days are everyday occurrences that people are exposed to. So what the company needs to do is to look at how their product's manufactured, determine whether or not a warning is required. If a warning is required, go ahead and put the warning on. If it's not required, you're fine. But one of the hard parts for companies is to figure out how to warn only for the California products. And I've talked to hundreds of companies that are in the distribution chain, either from retailers on up the chain of commerce, through a distributor, through a manufacturer, through somebody else. They don't know where their products are going these days. They can't just warn for products in California. So a decision to put a warning on a product means somebody in Minnesota, somebody in Maine may actually see the warning and go, hey, what the heck is this? And do I have something to worry about? And then the company will get a phone call.